Have a seat. Make yourself comfortable. All right. So, Mr. Crucell, you filed a number of motions. I'm going to let you pick which one you want to deal with first.
Well, this emergency motion stay needs to be addressed immediately, requesting the judicial bias and the process violation.
Okay, just hold off with the argument. Hold off with the argument. The question was, what do you want to start with? Okay. So you filed something Friday. I took a quick look at it today. Is that any different than the motion to stay that you filed previously?
This is just bringing the fact that all the motions I have filed.
Is that a yes or no, Mr. Crucell?
It's covering all the judicial bias.
Okay. Listen to my question. Is it any different than the last motion to stay proceedings you filed? Okay. Just give me what you've added since the last one, because this one I haven't had a chance to read fully. The first one I read fully.
I just have the same straight face on you didn't give a shit about what I had to say.
Okay, hold on. Mr. Crucell, this is going to be a very long day for you if you don't listen to my questions and answer my questions. That was in the original motion to stay proceedings. I've asked you to give me whatever's new in this motion.
New stuff covers Judge King Green telling me to sue the Secretary of State rather than addressing the due process violations in my case.
Okay, stop right there. How does that lead to why this should be stopped today?
All of this is stemming from where all of this should have been stopped a while ago.
That's not the way it works. Mr. Crucell, hold on. Okay. That's the last time you're going to interrupt me today without a contempt of court charge. Is that clear?
Your Honor.
Is that clear?
She gets me this entire time. No one has made her answer that.
One more word, and it's contempt of court. It's $100 a contempt, and if I get totally fed up with it, then I'm putting you in jail. Okay? Just because she and I happen to agree on the law as it applies to your case doesn't mean we're in collusion. It's possible that you're wrong. At least accept the possibility that she and I have the same opinion about something. That doesn't mean we're colluding. You understand that concept? Do you understand that concept?
You're supposed to be impartial.
I am impartial. I've been trying to save you. Just because I agree with the prosecutor doesn't mean I'm against you. It just means I agree with the prosecutor.
So it means if you're agreeing with that, definitely means you guys are lying against us.
So that means in any case, when I buy the arguments from one side, that means I'm colluding against the other.
You're agreeing.
Yes or no, Mr. Crucell? No, you have to answer my question. Contempt number one, $100. Answer my question. Every time I rule in favor of one side, does that mean I'm colluding against the other? Yes or no? $200. Yes or no? Because I can do this all damn day.
Buckle up, guys. Today we are going straight into a courtroom where the judge tries to keep control while the defendant pushes back at every turn. The moment he accuses the court of ignoring him, everything shifts. You can feel the tension rise as the judge warns him about contempt, making it clear this hearing will follow the rules whether he likes it or not.
I'm going to deny because that's an unreasonable position you're taking. Judges, by definition, have to decide in favor of one party or the other. That's what we do.
When you made that statement, you were making.
What statement is that?
It was,
I thought we were talking about Judge Green's SOS statement.
When you made this statement that you were setting aside my regular Travis saying that you're saying that the prosecutor, the township, and his court all see things the same way, setting it outside, not even allowing me to make my argument. So you were aligning yourself with the prosecution on the argument of my point and setting it aside on what you were doing.
Mr. Crucell, what I was doing was aligning myself with the law as I see it and interpret it. Stop. You can't just shake your head. You don't just disagree with me and move on. If you don't like a ruling from a judge, you have to appeal that ruling. You don't keep arguing with the ruling. That's not the way the process works. Listen, brother, listen. I have tried to save you from yourself. If you remember the first time you were in my courtroom, I tried to get you to see things the way the process was going to move forward. Because, dude, this process is going forward the way I want it to move forward. You might not like that, but I'm in charge of the courtroom. And at the end of the day, if you don't like anything I do, you can appeal me. That's why they have circuit courts. But I'm not going to let you make this a dog and pony show, especially when we've got jurors here.
Dog and pony show. This court has failed to let me make any of my statements, any of my cases, You even were trying to threaten me with contempt. Anytime I tried.
I am threatening you with contempt.
My objections on the record, you make my case. So you're
No,
saying-
no, because third contempt. Do not interrupt me. When I said your objections don't mean shit to me is because you were using the word objection inappropriately. You objected every time I disagreed with you.
The judge makes it unmistakably clear that courtroom patience has limits. When the defendant refuses to answer direct questions, the judge stacks contempt fines without hesitation. Every interruption turns into a penalty, and you see the power dynamic settle firmly on the judge's side while the defendant tries to push a narrative the court won't accept.
And you're trying to spin this here every time.
I'm not spinning.
My objection is based on you stopping me, not allowing me to do it. And that's when you told me my objection.
Okay. All right. So let's do it this way. What motion would you like to address first? The motion to postpone? Denied. I'm not denying the jury trial.
Especially with the jurisdiction, she's never once permitted it's on why it's on the prosecutor to prove those things. There's the false course irregularities.
All right. Let me stop you for a minute. What do you mean you're not going to proceed? You're here.
Everything is taking place now shows exactly that there is enough to show. You're supposed you need to keep shit.
Once again, you're not answering the question I asked. You just said you will not participate. And I asked, what do you mean by that? I'm not asking you to explain your reasoning. I want to know, what does that mean? I'm not going to proceed with this. You're here. So when I impanel the jury, what? You're just going to sit there and not going to talk? What does it mean when you say you're not going to participate?
And go through until these things get addressed. All of my issues that have been ignored this entire time, especially excluding people.
Once again, if you accept the motion and I deny it, it's been addressed. You might not like the way it's been addressed, but then you have to appeal it.
That's the whole point of me being able to get all my objections.
All right, what's your objection? What's your objection to me denying your motion to postpone this trial at the last minute?
Statement I'd like to put on the record is that if whatever you would like to do from there, you can, because I'm open until these things. Like I said,
Hold on. Is this statement preceding all these motions you filed?
all I
Okay, then let me make my ruling on all of them. I think there was a motion to dismiss for lack of jurisdiction, correct? Okay, would you like to respond to that one? Because I think that's already been addressed.
Please arrested Mr. Crusoe while he was in Huron Township, but if our district court has jurisdiction over offenses that occur within the township, both civil and criminal, this is criminal and
Did you appeal Judge Green's decision on that motion?
I'm prosecuting because I've been in contact with the appeals.
Okay, so there's no appeal filed yet, correct?
Getting all involved.
I'll take that as a yes. There's no appeal filed. That motion is denied then. She made the ruling. You don't get to ask me to make the same ruling. Once again, don't interrupt me because I can go to 4 real quick. Judge Green, a judge in this court, ruled on that exact motion and denied your motion. That motion.
Here the defendant threatens not to participate, hoping to derail the trial. The judge immediately presses for clarity, refusing to let vague statements pass. The courtroom becomes a chessboard, but the judge controls every move, repeatedly forcing the defendant to confront the consequences of his own decisions.
Listen to me. Then appeal her to circuit court. A judge made a ruling. You don't get to keep arguing that same motion.
All she said was that Judge Martin was setting aside and that I should go sue the Secretary of State. The things that she's claiming and saying were never said to me. And I have all the recordings and they're submitted to the court. These things were never said to me. And then she comes here and makes these accusations and saying that the judge said this, the judge said that.
Fine. Then I'll say the same. I'll say the same thing to you. Listen to me. Here, on your motion to dismiss for lack of jurisdiction, denied. By me, you can appeal me. Because the reason she stated, the Township of Huron issued you a citation. This court has jurisdiction over citations issued by the Township of Huron. So for that reason, I'm prepared to move forward and adjudicate that citation. Is that clear enough so you can appeal my decision?
Fine.
Okay. Next one up is motion to reconsider for bias and judicial misconduct. Denied. Would you like me to clarify that in any way?
Yes, absolutely.
Okay.
Okay.
Then guess what? The Court of Appeals can overturn me because I'm not biased to you. You might not like the way I talk to you. You might not like the things I say to you, but I'm not biased against you. Believe it or not, brother, I would like to save you from what's going to happen today. I really would. Because here's my dude, let me talk. You have turned what should be a fairly minor misdemeanor and civil infraction situation into a huge mess. I don't think it's going to end well for you. I tried to save you from that the first day you were here when I tried to convince you to have some conversation with a court-appointed attorney, and you didn't want to do all that. I know in my heart of hearts, I have no ill feeling towards you whatsoever. And I'm going to give you the best trial I can give you today if you decide to participate. But I am not going to let you drag things in front of this jury that I determine are not relevant, because that's my job as the gatekeeper at the judge over the trial. I'm not going to let you get into a bunch of arguments that I think are just going to cloud issues if I don't think they're relevant. That's my job as the judge, not because I don't like Mr. Crucell. It's because my job as a judge is to run this trial efficiently and effectively.
This part shows the judge dismantling the defendant's jurisdiction argument. The judge stresses that a township citation automatically grants authority to the court, shutting down the motion to dismiss. Even claims of bias collapse when the judge reminds him that appeals, not arguments, are the proper remedy. It's a sharp reality check.
Certain acknowledge my motions for my next travel.
Once again, I'm doing my function as a gatekeeper for a jury trial. I'm deciding what's relevant and what's not. And you can disagree with me that all day long. But we're going to do it, once again, we're going to do it my way. You can appeal me. I've been appealed before. I'll probably be appealed before I retire again. It's okay. That's the way the process is set up. I encourage you to appeal me. All right. I am open-minded enough to think that perhaps my mindset about your whole thing, maybe that's all wrong. So a circuit court judge can tell me I'm wrong. But so far, and I've ruled this way a number of times on the traveling issue, nobody's ever appealed me to lead to a circuit court judge to tell me I'm wrong. But I'm open to that idea.
I said, well, you just keep, each judge has done the same thing. They just keep setting it aside. In fact, I think it doesn't even exist, not allow me to make my case, which is violating my rights to be able to produce my case in my head.
What's your case that traveling doesn't mean operating?
I'm exception. In fact, this court's violated my due process rights in every way, the judicial bias. And
all right, then appeal me. But today we're having a jury trial.
An unlawful jury trial, and I think that late statement I need to get on the record.
Right, but hold on a minute. Once again, I want to know what that means. You're not participating.
Not participate in a jury in a trial where there is clear bias in this court against it.
Okay.
It violates my rights to a fair trial. 100%. And you want to keep overlooking. I know that makes you seem like they're not a big deal. And
no, your rights are a really big deal.
Obviously not, because if you can sit there and say that the things that are happening, the things you're saying, and just try to give these excuses, oh, just because I agree on this, you are aligning yourself with the prosecutor on my right to trial, completely setting aside, not allowing me.
Mr. Purcell, no, I'm not. Listen to me. No, it's not. Listen to me. Listen to me. She could step out of the room, and I still think your travel argument is bullshit. Traveling. The right to travel was when you did it.
The judge explains the gatekeeper role with complete authority. He draws a clear line between legal arguments and what the jury is allowed to hear. The defendant keeps insisting his motions matter more than the trial itself, but the judge calmly reins him back, reminding him that the courtroom isn't a stage for theories, it's a place for facts.
It's my decision. Appeal me. When you're driving a motorized vehicle or traveling in a motorized vehicle, that brings all those ordinances into play. That's my legal ruling. Appeal it. I encourage you to do that. But that whole traveling argument, which, dude, I've been through that argument a whole lot more than you have. Trust me, in the last 25 years, I've had that argument a lot. Traveling as you try to apply it meant you could not be stopped by the government from walking from one venue to another. But when we got motorized, then the rules kicked in.
Rulings from the American jurisprudence side that literally state that yes, first of all, you're allowed, and including automobiles, as long as one does not interfere with another's rights. And this has been something that's been established to be here.
Then appeal me. Take that precedent and appeal me.
As well.
Okay, that's your right. I'm not trying to stop you from doing any of that stuff. I'm just trying to stop you from bogging down this jury with stuff that I've determined is not appropriate today.
Because just because you're determining it based off of what though? That's what I'm saying. All these things are relevant and they are accurate.
They're relevant to you. They're not relevant to me. I've made the decision. I have made the decision. I made that decision months ago and you didn't appeal that.
I mean, the process we're kind of,
Which is not an appeal.
is an extreme, lawyer when there's bullshit that you can't do that.
Absolutely, I do.
This section delivers one of the clearest explanations of the travel versus drive myth. The judge breaks it down cleanly. Walking is a right. Operating a vehicle is a regulated privilege. The defendant tries to cite case law, but the judge encourages him to appeal instead. It's the perfect example of legal reality clashing with sovereign ideology.
Hold on. I don't doubt that it is. But I think we got into this a little bit the first time you were here, and I told you that's not proper for this venue. If you want to complain about the way the Huron Township Police Department handled this, you can file a civil lawsuit against them if you want to. But what's in front of me is one civil infraction and 2 misdemeanors. That's what's in front of me.
Oh, every time I force it to make my case, the court will keep setting all my stuff and not allowing me to be heard.
Because I'm going to make decisions based on the facts. That jury hopefully is going to make decisions based on the facts that are presented.
How can there be facts if this court continues to not allow me to get my facts?
Because the facts you want to get into, what facts do you want to get into? The chief had some conversation with you?
It's not even just that. I mean, well, yeah, regardless, I have all of that to cover too. The fact that my defense, based off what I was doing, I didn't have to produce any of that. It just keeps all just thrown aside. Every single bit, and just not even trying to acknowledge any of it.
So hold on. I don't understand. Hold on. You want to be able to testify to this jury?
No, it's not. I'm not testifying. That's what I'm saying. Until the amount of judicial
Bias.
Well, I don't feel that I would have a fair trial here with everything that's been taking place. Why I file policy? Why I did.
And I've denied all these things.
Now the defendant leans heavily into accusations of bias, insisting the system is stacked against him. The judge responds with firm composure, noting that disagreement does not equal discrimination. He repeats that he knows his own impartiality, and any challenge should go to the appropriate appellate channels. The courtroom tone tightens further.
That's just the reality of it.
That's what I have to do. Because this court's not going to rule it the way it's supposed to. I'm not going to stand by your judicial.
Not by your definition, I'm not.
The Secretary of State, Attorney General, and you. I've never heard anything. I don't even know if you're lawfully allowed to concede it. You can say, but again, it needs to be proven on the record.
No, it doesn't need to be proven on the record. Show me a statute or a court rule in Michigan that says I got to prove that. Michigan statute or Michigan court rule says I've got to do that.
I have it in there. My father was in this motion.
So you're such a great legal scholar.
MCL 168.420 and MCL 168.467 mandates that the judge must file it over with the state, and you provide it when asked. That is what it is. Yeah, lengthy statement. I would love to put on the record before we get.
How lengthy?
Minutes.
Go ahead.
Respectfully,
Just so you know, you're putting this on the record. You're putting this on the record. I'm not listening. Showcase the record.
Your Honor, Judge Oak, I respectfully assert that this court has failed to by the files of the case. Yeah, well, then so she can make it right.
Thank you.
I respectfully assert this court has failed to address the critical motions I filed in this case, including a motion to dismiss for lack of jurisdiction, a motion to.
The tension deepens as the judge explains appeals and judicial grievance procedures. He clarifies that he doesn't need to prove his lack of bias because he knows his own intent. The defendant keeps circling back, but every claim collapses as the judge stands on experience, authority, and the structure of the legal system.
Use of bias and a motion for relief from judgment. These motions have raised significant concerns about the court's jurisdiction, judicial bias, and violations of due process under both the Michigan Constitution and the U.S. Constitution, particularly the 5th and 14th Amendments. I have also submitted affidavits and motions, including an affidavit of truth and an affidavit of rebuttal regarding the traffic stop by Officer Merrill, which is connected to this case on August 21st, 2023. Citation number 24HR-10143, which this court also ignored. These documents directly challenge the jurisdiction of the state in this court, and failure to address them constitute a violation of due process rights. Additionally, I have filed an affidavit of not consent, a motion for judicial notice, a motion for clarification of accuser, none of which may be acknowledged by the court. In Marbury v. Madison 5 U.S. 137, the U.S. Supreme Court clearly established that any law repugnant to the Constitution is void. I believe the action or lack thereof of the court violate fundamental constitutional principles. In Murdoch v. Pennsylvania 319 U.S. 105, the court reaffirmed that no state may impose fees or penalties for exercising a constitutional right. And Thompson v. Smith 155 reinforced that the fundamental right to travel freely without undue USC 556D, 557, and 706 require that any judicial or administrative proceeding be fair, free from bias, and based on factual evidence. I have serious concerns that this court has disregarded this evidence. I have serious concern this court has disregarded these principles, given its method of dismissing my motions and statements made by Your Honor, who has stated on record that we see things the same way, referring to the prosecutor, township, state, and this court. This admission clearly demonstrates judicial bias and lack of impartiality, which undermines the fairness of these proceedings. It is also significant that Judge Tina Green has admitted in court that the Secretary of State is influencing the rulings, stating that the court is required to enforce certain rulings because of the Secretary of State makes them do so. This further demonstrates that this court is not acting as an impartial judicial body, but is enforcing motor vehicle codes, other rulings based on external directives rather than applying.
The defendant launches into a full sovereign-style declaration, listing motions, affidavits, constitutional claims, and accusations of corruption. The judge listens, then redirects everything back to the core issue. The trial will proceed within the law, not theory. It's a perfect closing moment showing the difference between personal belief and courtroom reality.
Law independently. The Secretary of State is an executive branch agency, and his influence over judicial proceedings is a violation of the separation of powers and the constitutional right to an independent, fair trial. Furthermore, there is clear evidence of collusion between the prosecutor, Huron Township, including the Huron Township Police Department. I have submitted body cam footage highlighting violations of department policies by several officers, including Officer Merrill, Officer Syside, Officer Smith, and Chief Everett Robbins. These violations occurred even after Sergeant Price confirmed that my activities were lawful, yet this court continues to overlook these crucial facts. Officer Merrill's traffic stops of both myself and my wife are connected to the ongoing retaliation against me and my family, which has compounded the bias and misconduct in this case. Additionally, I have requested Your Honor's oath of office through an affidavit of fact, registration statement, demand request pursuant to the Foreign Agent Registration Act of 1938, and anti-bribery statement request, and I have received no response. This lack of response raises further questions about the legitimacy and legal standing of this court. Moreover, Judge Lisa Norton issued an unsigned default order without jurisdiction or court seal, and during court proceedings, she admitted she did not understand the sui jurisdiction. These actions reflect further incompetence and violations of due process. I must also address the township's deliberate attempt to mislabel my private automobile as an off-road vehicle under local ordinance to circumvent my constitutional right to travel. This mislabeling is an attempt to subject me to commercial regulations that do not apply to private, non-commercial travel. This ORV ordinance was never intended for public roads. Under the Clearfield Trust Code, United States 318 U.S. 363, when government entities operate in commercial capacity, they lose sovereign immunity and are subject to the same legal standards as private corporations. The court's actions, including the misapplication of commercial motor vehicle codes, further demonstrate its commercial interest in misinterpretation of the law. The supremacy clause of the U.S. Constitution, Article 6, Paragraph 2, mandates that this court is bound by the Constitution, which is the supreme law of the land. This court, however, continues to proceed without regard for constitutional protections, violating my rights at every stage of these proceedings.